Friends, welcome to the 127th session of Legal Empowerment Through Interaction lecture series. As the journey continues, transcending national boundaries, we respect and pay homage to those wonderful persons who had done a yeoman service, making us understand that law as a means of social change is not just in papers, but can be done. This could be one of the sessions wherein we can fully and finally understand that there is something known as the power of one. Usually something goes wrong, we look around for persons and things to help us and we wait for the Messiah to come and save us. But whereas a puny, like Mahatma Gandhi, I can say, like, I mean, he was not somebody who was imposing or anything, but his size didn't matter. His conviction, the way in which he could deal with the subject, the fight with the mighty British Empire. Likewise, today's topic is regarding RBG, for short we use, and she changed the entire legal scenario, not just for gender equality or gender mainstreaming, but the way in which the Supreme Court of America was perceived. To deal with the subject, we have a wonderful speaker who is part and parcel of this platform, Neema Noor, and to introduce that again by none else than our own Prem, and we are privileged with the presence of Justice V. Ramkumar. So this in fact is a in-house discussion, deliberation with all of you wonderful extended family members of letils. Let us have the next 1 hour or so fully understanding or imbibing something which is very close to all of us. How a person can bring about change, how law, the force, the might of law can be used to bring about a social change. Prem, over to you.
Good afternoon to all of you.
Good afternoon.
Today, I have been told by the speaker not to be too brief, but to give a broad outline regarding the topic. And especially when I was talking to Shyam, he also told me to lay some special emphasis on the prevalent systems, the constitutional powers, provisions, etc., with regard to the highest courts in USA as well as in India, so that the speaker of the day could lay a foundation on the topic on which she would build her sides. Justice Ruth Ginsburg, who earned the moniker as Notorious RBG for her scathing dissents during the 27-year-old tenure as a second lady judge in the United States Supreme Court. She served for a span of 27 years. And the US Supreme Court, which was established in 1789, till date, merely had 4 lady judges. The first one was Justice Sandra Day O'Connor, who was appointed during 1981. And apart from Justice Ginsburg, we have another 2 lady judges by name. One is Justice Sonia Sotomayor, and the other is Justice Elena Kagan, both of whom are still serving. Now, the Jewish-born Justice Ginsburg, after serving as a professor in Rutgers University Law School and subsequently at Columbia University, went on to serve as a director of Women's Rights Project of the American Civil Liberties during 1970s. After that, she was appointed to the US Court of Appeals for the District of Columbia in 1980 by President Jimmy Carter, and finally named to the US Supreme Court in 1993 by the then President Bill Clinton, after Justice Byron White demitted the office. Justice Ginsburg is a legal, cultural, and feminist icon, and she was the bastion of gender constitutionality all across the globe. Now, prior to this topic, which is being dealt with by the speaker at great length, one needs to realize some of the vital or important differences between the Indian and the US constitutions, the nature of the governments, the appointments of the judges, their tenures, and also the powers of the Supreme Courts, which are to be borne in mind while analyzing the subject also. First, to deal with the Constitution, the American Constitution, that is the shortest of any major government in the world, and the first written Constitution. India's Constitution, on the other hand, that is the lengthiest written Constitution in the world. Originally, as we know, our Constitution had 395 articles in 22 parts with 8 schedules. Now it consists roughly around 450 articles. I am saying the total numbers, which would include when it is renumbered as A, B, C up to Z and all we have regarding the Panchayat and all. Quite the later amendments, and I have not counted, so I may be excused if I am wrong. And now we have 12 schedules in total. The American Constitution is a very rigid constitution, which consists only of 7 articles, and they have only 27 amendments so far, and we have crossed 100 long back. Now we know the American Constitution was finalized on 17th September of 1787, which required its ratification by a minimum of 9 states for it to be enforced. And by the end of, say, July 1788, 11 states ratified it, and the Constitution was put into operation on 13th of September 1788. The Indian Constitution, which has been adopted by us, our Constituent Assembly, on 26th of November 1949, that comes into effect on 26th January 1950. US adopted the doctrine of dualship in respect of the Constitution as well as the citizenship. Now, it has 2 constitutions. One is for the whole of America and the other for each state. The American people thus have 2 citizenships. One is of USA and the other is of their respective states. On the other hand, we have one constitution and the concept of single citizenship for every citizen of the country. Now, the American Constitution is described as a truly federal constitution, which was subsequently ratified by around 50 independent states. Further, the federal government and the states have their own constitutions and they do not interfere in each other's functions. On the other hand, when we have only one constitution, the central government interferes with the functions of the state governments in many fields. For example, just take the appointment of governors. Then the governor is having the power of reserving the state's bill for the consent of the president. Then the central government's power to impose the presidential rule in the states, etc., which are a few to go. While USA, it's a dual federation. India, I would say it's a cooperative federation. Now, coming to the US Supreme Court and the Supreme Court of India. In the Supreme Court of India, only federal cases come under the original jurisdiction. But before the US Supreme Court, not only federal cases, the cases of naval forces, maritime activities, ambassadors, everything would come within its original jurisdiction. Our Supreme Court has only a very restricted ambit of judicial review when compared to the wide powers of the US Supreme Court. Now we have an integrated judiciary, and the Supreme Court of India has some control and superintendent's powers over even the high courts. Whereas in US, there is a separate judiciary for the state and the federation. And being so, there is no control or supervision or superintendents are available for them. Now, our Supreme Court has the advisory jurisdiction, which is there not in the US Supreme Court, not for the US Supreme Court, because their constitution does not permit so. Now, the appellate powers of the Supreme Court of India, that includes constitutional, civil, criminal, everything. But US Supreme Court, that is restricted merely to constitutional matters. Our Supreme Court has the power under Article 136 to grant special leave to appeal in any matter of any judgment of any court or tribunal except the Armed Forces Tribunal, and thus has a very wide discretionary power. The US Supreme Court, on the other hand, has no such power. And finally, the jurisdictions and the powers of the Indian Supreme Court that can be enlarged by the Parliament, which we have another provision in the Constitution. But the jurisdiction and power of the American Supreme Court, it is too limited to that which is conferred by the Constitution. Now, going to the mode of appointment of judges in the highest court. As we all know, that for a democracy to survive, it is very essential that its people should have faith in judiciary. After the Almighty, judges are trusted and they are given the power to order taking even a human life or putting a person behind the bars or punishing them so as to ensure that a just society where justice only prevails. This is the concept. Judiciary plays a very pivotal role in dispensing justice, and the constitutional powers regarding the appointment of judges of the Supreme Court and the High Court, which we see in Supreme Court, we see in Article 124 Clause 2, whereas for the High Court we have Article 217 Clause 1 of the Constitution. As far as the appointments are concerned, the executive as such, they do not have the final say because we have the collegium system with regard to the direct elevation. The senior-most DJs, I mean the district judges, they are elevated to the High Court if it is from service. When if to the Supreme Court, from amongst the High Court judges, there is no set pattern of seniority, as we all know. Then, ours is a democratic country which has seen appointments of Chief Justices of the Supreme Court overlooking the seniority of judges, at least, thrice. Though the first one was one seeking a compulsory resignation the day before the next Chief Justice assumes his office. The first one, before I go to the first one itself, in 1954, Pandit Jawaharlal Nehru, he wanted to appoint M.C. Chagla as a Chief Justice of India directly, as he was not too fond of Justice M.C. Mahajan. On the retirement of the then Chief Justice Patanjali Shastri in January 1954, he wanted to supersede Justice Mahajan, who, as the next senior most judge, he was slated to become the Indian Chief Justice. Now, Jawaharlal Nehru offers this post to Justice S.R. Das and even to Justice Vivian Bose. They didn't bite the bait. It was then Nehru started toying with the legendary Chief Justice of Bombay, M.C. Chagla, at which point of time, all the judges of the Supreme Court, who were 7 in numbers at that point of time, they told Nehru that if he wanted a Chief Justice other than Justice Mahajan, he might well think of having a whole new Supreme Court and that they would all resign. And Nehru had to back out. We see that the judges stood as one, not merely for Justice Mahajan as an individual, but it was for the institution as such. 10 years thereafter, in 1964, we have the first case. Justice Syed Jafar Imam, who was in line to be the Chief Justice of India. The Supreme Court faces a very embarrassing situation concerning the health of this particular judge. And the story has been penned in India's first Attorney General, M.C. Setalwat's memoir, My Life, Law and Other Things. Justice Jafar Imam, after having fallen ill, he did not sit in the court since a few months. Subsequently, when he resumes the work, it was felt by both the judges as well as the lawyers that he has not fully recuperated and that he was not really competent to discharge the duties. The outgoing Chief Justice was Justice B.P. Sinha. He called Setalwat and the then Attorney General C.K. Daftari for a meeting, and Justice P.B. Gajendra Gadkar, who was the next senior most, he also was present. They discussed how the matter could be resolved. And later, Daftari and Setalwat met the Prime Minister, who was again Jawaharlal Nehru at that point of time, to seek his indecision. And Nehru told them that the government already had the medical report with regard to Justice Jafar. Beg your pardon, sir? Justice Jafar Imam, which indicated that he was not fit to discharge his duties. He assured them that it would be possible to bring about a retirement without moving the parliament. And Nehru, of course, he succeeded in persuading Justice Imam to resign. And the second case is Justice A.M. Ray superseding 3 judges, Justice Shelagh, Justice Grover, and Justice Hegde, to become the Chief Justice of India immediately after the Keshavananda Bharati verdict, which is reported in the year 1973, Supreme Court 1461. In a book which is titled as Supreme Whispers, which is authored by Abhinav Chandrachud, the grandson of the Chief Justice of India, Y.B. Chandrachud, and the son of the now Justice D.Y. Chandrachud, Justice Ray is quoted to have said that he was only given 2 hours to think of accepting the post, and that if he didn't accept the post, someone else would be offered, and that he has not hankered for it. It appears that the government of the day, they wanted the judges also to be very committed to socialism. The superseded judges resigned to remind the executive not to interfere. Again, we have the case in 1977 when Justice Beg, he supersedes Justice Khanna to become the Chief Justice of India, and Justice Khanna resigned pursuant to his famous dissent in the ADM Jabalpur case, 1976 2 SCC 521. Now then starts the struggle for power. This struggle for power, this culminates ultimately in the court wresting the power of appointment of judges from the government through major rulings. There are 3 major rulings. Of course, there are 4, but let us, to begin with, these 4. One was the first ruling was S.P. Gupta versus Union of India, which is known as the first judge's case. It was a 7-judge bench decision, reported in AR 1982, Supreme Court 149. The second one, the 9-judge bench in Supreme Court Advocates on Record Association versus Union of India, 1993 4 SCC 441, which again got reaffirmed by unanimously by a 9-judge bench in the special reference 1998 7 SCC 739. USA, on the other hand, has a dual system of courts, namely the state courts and the federal court. Now, the federal courts consist of the Supreme Court of USA, the Court of Appeal, and the District Court. Now, the constitutional provisions regarding the appointment of judges, it is dealt with in Article 2 of their constitution, which states that the President shall nominate by and with the advice and consent of the Senate, appoint the judges of the Supreme Court and all other officers of the United States. Now, the justices of the Supreme Court, the judges of the circuit courts of appeals and the district courts, they are all appointed by the President of the United States with the advice and consent of the Senate. Now, these justices and judges, they are appointed for life. And mind you, they can only be removed through impeachment by the Congress. Right? We are the same thing as we have here. Now, with regard to the procedure of appointment, whenever any vacancy comes into the federal court, the Department of Justice, they notifies with the White House and then sends the recommendation for nominating the persons for the same post to the President. On approval, these recommendations, they are sent to the Senate. Now, the Senate refers these recommendations to the Senate Judicial Committee. And if the committee passes the nomination with majority, the President gives the final approval by signing these nominations. Now, a comparison of the procedure of appointment of judges in India and USA, it makes it clear that three major differences between these two countries are: one is that in USA, the President nominates the judges and appoints them with the approval of the Senate, while in India, the recommendation is sent to the President by the Collegium, which consists of 4 senior-most judges of the Supreme Court of India and the Chief Justice, total 5 judges. Second one, in USA, if the Senate, which is the House of Parliament, as we have, they passes the candidacy of the nominated person by the President by majority vote, then only the President can appoint the person so selected. While in India, the Parliament has no such role to play. And finally, the Indian system of appointment of judges has evolved over years from the entire power being vested in the executive till 1993. Later, we saw a bunch of review petitions which were filed. I think those were filed during years thereafter. We have seen seeking a review as against the second judge's case of 1993. And last year, we saw all those review petitions. They were dismissed by a 9-judge bench, which was headed by the then Chief Justice Ranjan Gogoi, on the ground of delay of more than 9,000 days. Subsequently, the government enacts the NJC Act that was introduced, and we saw the same being struck down by the Supreme Court in again Supreme Court Advocates on Record Association's case, which is reported in 2016 5 SCC page 1. And now we see constant attempts to reach to a memorandum of procedure which can accommodate the proposals of both the judiciary and the executive. Mind you, there is no such tussle or confusion in the appointment process in USA. Now, that apart, unlike the federal judges in US, the judges in India, they do not hold their office for life. Our judges, they retire at the age of 65 as far as Supreme Court judges are concerned, and 62 as far as the High Court judges are concerned. And these judges, they do not hold their offices at the pleasure of the President. They can be removed by impeachment by a supermajority of both houses of the Parliament on the ground of either court misbehavior or incapacity. And as we know that the impeachment process, it's a very difficult one. The history of independent India has never seen a judge being impeached, though attempts have been sometimes made to do so. Now, coming back to Justice Ginsburg. Justice Ginsburg consistently interpreted the Establishment Clause of the First Amendment to the US Constitution to provide for a high degree of separation of church and the state, and she authored several majority opinions in such cases. Among them are Ibanez versus Florida Department of Business and Professional Regulation, which is a 1994 ruling, which deals with a commercial speech. Then you have Buckley versus American Constitutional Law Foundation of 1999, a political speech case. Eldred versus Ashcroft of 2003, a ruling that extends to copyright protection. You have Illinois, represented by its Attorney General, Lisa Madigan versus Telemarketing Associates of 2003, which it's a decision about charitable solicitations. You have the Christian Society chapter of the University of California versus Martinez, which is a 2010 decision, which upholds the university's policy against discrimination, even as applied to student religious groups. Golan versus Holder, a 2012 matter, a case which rejects a First Amendment challenge to a copyright law. Then Wood versus Moss, a case which granted qualified immunity to Secret Service agents who allegedly treated the anti-president protesters worse than cheering for the president. Of course, Justice Ginsburg frequently voted in a First Amendment friendly manner, in dissent also. What I said was the majority judgments. She dissented from the majority opinion, first in the Capitol Square Review and Advisory Board versus Pinett, 1995 decision, reversing a decision that denied a particular permit which you call the Ku Klux Klan, a permit which is meant to leave an unattended cross on the State House Square in Columbus, at Ohio. She joins Justice Anthony Kennedy's potent dissent in an attorney advertising decision in Florida Bar versus West. I think it is West. That's a 1995 decision. Another famous dissent was in City of Erie versus Pax of 2000, wherein she ruled that an ordinance against the nude dancing that does not violate the principle of free expression. Justice Ginsburg generally has been a strong defender of commercial speech, which is evident from her dissent in Zellman versus Simmons Harris of 2002, when the majority upholds the Ohio school voucher law, which provided tuition assistance for religious and non-religious school. And then in Van Onden versus Perry, which is a 2005 decision, when the majority upheld the constitutionality of a display of 10 commandments in a public park in Austin, Texas. Then she joins Justice Paul Stevens. Of course, they were the only dissenters also in Beard versus Banks. That's a 2006 decision where the court majority rejected a prisoner's claim that the prison's ban on reading material that violated the First Amendment. Likewise, in FCC versus Fox of 2009, she showed some doubt as to the validity of the court's decision in the earlier broadcast indecency case which was there in USA. That is FCC versus Pacifica Foundation. That's a 1978 judgment. And of course, we have a lot more. Bush versus Gore, then Ledbetter versus Good Tire Companies. Ever so many judgments are there. Now, Justice Ginsburg, who died around 10 days back, that's on 18th of September this year, she has left behind a stout legacy all across the globe. And her contributions to the human race impacted not merely USA, but even our Supreme Court as well. We know that the US is the oldest living democracy, and their Supreme Court, it is a part of their constitution. And our constitution, of course, we have borrowed several features from the US Constitution, which even includes fundamental rights, making, of course, suitable changes which could suit the Indian conditions to address certain issues like what you say, the caste, child labor, untouchability, and so on. And our courts still cite the judgments of our US Supreme Court on issues affecting fundamental rights. As we could see in the 7-judge bench, which was Karthi Rani Rawat's case, AR 1952 Supreme Court 123, which was the first case where the apex court sits in its full strength of 7. Considering the constitutional validity of the Saurashtra state, they had the Public Safety Measures Amendment Ordinance of 1949, and the then Chief Justice Patanjali Shastri, speaking for the bench, went on to consider the US Supreme Court judgments in Bowman versus Lewis. And Justice B.K. Mukherjee, who wrote a separate judgment, he cited 3 judgments of the United States Supreme Court, like Hopkins judgment, the Crowley judgment, then you had the Gunling judgment, and even Chinga versus Texas of 1940. And in the same judgment, Justice S.R. Das, he delivers another separate judgment. And he cites Skinner versus Oklahoma, which was a 1942 judgment. Another celebrated case which we have in our constitutional history is Maneka Gandhi's case, AR 1978 Supreme Court 591, wherein the Apex Code interpreted the most cherished, valuable fundamental right, the most cherished human right, and held that Article 21, the right to life, it is not a mere animal existence, but right to live with dignity, and the procedure by which it could be infringed by the state, it should be just, fair, and reasonable. And to hold so, if we have a close look in the judgment, to hold so, Justice Bhagavati compared Article 21 with the similar provisions of the US Constitution and referred to several US Supreme Court judgments like Kent versus Dulles of 1958. Then they had the Aptekar versus Secretary of State of 1964. Then Semel versus Rusk of 1966, and so on, which were concurred by Justice Hidayatullah and Justice Kailasam. And recently, Justice Nariman in Ravi Shankar versus State of Madhya Pradesh, AR 2019 Supreme Court 5347, he was dealing with an issue of awarding death sentence after drawing a balance sheet weighing the mitigating circumstances as against aggravating circumstances, and that in a case of rape and murder of a 13-year-old girl. He went on to explore the theory of residual doubt, and he refers to the US judgments in Herrera versus Collins of 1993 and State versus McKinney, that is by the Tennis Court of Appeal in 2002. The views of Justice Ginsburg, even her dissents, they find a place in the major decisions of our Supreme Court. The first one is a three-judge bench decision in Consumer Education and Research Center versus Union of India, 1995 3 SEC 42, considering a public interest litigation, which was a one filed under Article 32, regarding the violations of the right to health on occupational health hazards and diseases to the workmen who were employed in the asbestos industries. Justice Ramaswamy, who was speaking for the bench, he went on to refer Blaney Wilson versus Johns Maniley Sales Corporation's case of 1982, in which Justice Ginsburg, as a judge of the Court of Appeal, as she was in the District of Columbia Circuit, deciding the question of limitation of 3 years from the date of diagnosis of a mild asbestos disease, held that the period of 3 years that should be computed from the date of discovery, and the asbestos, which is not a cancerous process, it has a latent period up to 10 to 25 years between initial exposure and the apparent effect. Then you have Saurabh Chowdhury's case, 2003, 11 SCC 146. The Constitutional Bench decision was concerned with the validity of reservation in government-run medical colleges based on domicile. And concurrent with Chief Justice Khare's view, Justice S.B. Sinha, he refers to the minority view of Justice Ginsburg with Justice Kauter in Jennifer Gratz and Patrick Hamak. Then you have Chinnaya versus State of Andhra Pradesh, which is report in AR 2005, Supreme Court 162, which again is a constitutional bench decision which deals with the issue of reservation. And the fact that the benefit of reservation was not percolating down to the most deserving class among the scheduled caste, delivering a separate judgment. The same Justice Sinha, he refers to the same minority view of Justice Ginsburg and upholds Justice Ginsburg dissenting views to be in tune again with our constitutional scheme. You have Ashok Kumar Thakur versus Union of India, that is 2008 6 SEC page 1. Another constitutional bench of the Apex Court, concerning the Constitution's 93rd Amendment Act of 2005 and the enactment of the Central Educational Institutions Reservations in Admission Act of 2006, which provides reservation to the OBCs, the SCs and the STs. And Chief Justice K.G. Balakrishnan heavily relies upon the statement made by Justice Ginsburg in the 51st Cardozo Memorial Lecture in 1999. Then you have Anuj Garg versus Hotel Association of India, AR 2008 Supreme Court 663, with Justice S.B. Sinha dealing with the issue of discrimination of women from working in public places serving liquor, relies on the observation of Justice Ginsburg in United States versus Virginia, a 1996 decision, as to how the court should look at differential treatment on the basis of gender. Why? You have Justice Puttaswamy's case, 2017, 10 SEC page 1, which we popularly know as the right to privacy judgment. The majority of a 9-judge bench speaking through Justice D.Y. Chandrachud relies on the dissenting view of Justice Ginsburg in Minnesota versus Carter of 1998, being joined by Justice Stevens and Justice Kauter. And of course, later in Navtej Singh Johar versus Union of India, 2018 10 SEC page 1, which again is a constitutional bench decision of the apex court, whereby section 377 IPC was struck down to decriminalize that section. I mean, the consensual adult sex of whatever sexual orientation in light of privacy. And this time, Justice Chandrachud relied on the dissenting view of Justice Ginsburg, along with the other lady judge, Justice Sonia Sotomayor, in Masterpiece Cake Shop versus Colorado Civil Rights Commission of 2018. And now, recently, we have the apex court is seized with the challenge to the Citizenship Amendment Act of 2019. And the minority opinion of Justice Ginsburg in Trump versus Hawaii, it's a 2018 decision, surely will be cited, notwithstanding whether the Supreme Court favors it or not. In that case, the majority found no illegality in President Trump's travel policies, and the minority opinion of Justice Sonia Sotomayor, in which Justice Ginsburg agreed, went on to say that the United States of America, it's a nation which is built upon the promise of religious liberty. And the founders of the Constitution, they honored that the core promise by embedding the principle of religious neutrality in the First Amendment. And this view, of course, is applicable to India because secularism, it's a very basic feature of the Indian Constitution as well. Now, the Speaker of the day, Mrs. Neema Noor, who is now an assistant public prosecutor in the Mahila Court at Saket, New Delhi. She began her practice in Kerala and then shifted to the Supreme Court of India. And she has an exemplary academic record. She was a gold medalist in BSc microbiology, and she was a topper in the LLB examinations as well. Subsequently, she did her master's from the Indian Law Institute, and she secured the highest grade in the LLM dissertation. And several articles of hers, it has been published in many national journals. And she has, in fact, authored a book on the law of divorce and gender inequality in Islam. I know I have taken more time than a conventional topic introduction, but it is only because I have been so told by the speaker, who would now talk at more length. And the speaker would, of course, recall the monumental effect of Justice Ginsburg on the fight for equality in the United States and its effect in our country as well. And let this be a tribute to Justice Ginsburg, who, of course, I would term as the founding mother of the United States gender equality jurisprudence. Now, over to you, Neema. All yours.
Hi. Well, it was really, indeed, as promised. Thank you so much, Premraj. It was indeed, I take this opportunity as an honor for me because I'm being given a chance to speak about one of, the most, a legend. I would use that word, that would be most appropriate when you use the word for Justice Ruth. Well, first of all, let me thank the entire teams of Letils, because as I told earlier also, this is like a family get-together for me, an evening coffee time. So I'm not taking it, I'm not making it more formal with regard to all the stands and all. So as, I call Premet in, so I don't know, like, I have to address. So like, as he said, like, what is the relevance? Why are we speaking about her at this point of time is very important. When I was a law student and I was doing my moot court competitions, I still remember there was this case of Roe versus Wade that came into my mind. That was the theme that was said at that point of time. That was the moot question all about. And when we were asked to research on this topic, what we were asked first was, you have to prepare for the both sides. So when I wanted a critical analysis of this particular judgment, I had no other option, but I had to read in full length what a critical analysis Justice Ruth Ginsburg had given on this particular abortion rights. And that is how I started to find interest in reading more about her. Probably, I would say I started to build that fandom around her at that point of time. Well, as this topic says, the impressive bequests of RGB, the civil rights gladiator. Yeah, and I think the credit goes to Advocate Premraj, who has drafted this particular title, and it is actually verbatim suiting to that gladiator who was left us 10 days back. Now, this is where the relevance is. Why are we discussing RGB is a question. She is far away in some continent and we sitting in India. Why do you want to discuss RGB? What is the relevance that RGB has to our particular context? My voice is echoing.
No, no, it's okay.
Okay,
Carry
okay,
on.
yeah. Okay, yeah. So the question is, so why, when I was asked to present on this topic, I was like literally happy because we usually as Indians are very reluctant to, give a founding tribute to such a person, especially I would say, which is nobody to be amongst us. But here is the relevance of RGB. Why? Because she was not just a judge. She was, as the title says, a gladiator, a crusader. I would say a messiah in that terms. America was very lucky to have an RGB born there. Though Jewish, she was born there. So, and my question, why are we discussing, will you get that answer within 40 minutes of my, I mean, not 40, I would like it less, of my discussion on her will make you understand why are we discussing her and what is the relevance of the notorious RGB in the present context and for the legal world. Now, before I start about RGB, I love to call her like that because it looks very fancy to me. Before that, I think before reading RGB, we need to look into the history of America. You know, where did RGB, why was RGB born? RGB born in the sense, the so-called RGB, RGB is no more a person for me. Now she's a phenomenon. Okay, you're going to relate it like that. Okay, so why was RGB born? This is because RGB now is synonymous to a phenomenon. Okay, so why was such a phenomenon happen to her, be born in America? It's just because of the history. And I'm taking the audience to the history of America at the point of time where America is still fighting for equality, unlike the rest of the continents. Unfortunate, though America, the so-called glorified America that we all look at, is still fighting racism. This is where the history begins. You won't believe, in the year 1787, only 5 of the 13 states had abolished slavery. That is, you mean the 18th century. Okay. And women did not count as a part of the franchise holding. She was not politically active. Yeah, hello. Yeah, am I?
Yeah, we are hearing. We are hearing. Yes,
Actually,
audible.
yeah, fine. So what happened was, the women was not politically active community in any state, to the shock. And this particular so-called voting eligibility was only given to the elite white males. Okay, now here comes the break. That was, I think, every constitutional law student would have read around Brown versus Board of Education. The citation goes for the students, if any, is 347 US 483, a judgment which came out in the year 1954. This 1984 decision helped, to declare that, I mean, the racial segregation that was existing in America at that point of time, it held that in public school, it is against the equal protection principle that America had imbibed in the Constitution. And in this particular point of time, they happened to, break their particular principle called separate but equal. That was a principle that they were built, America was built at that point of time. You are separate but equal. I don't know what logic it was. That was how it followed till the Brown versus Board of Education judgment. Now, so fortunate to have such a wonderful judgment. This particular judgment gave strength to the civil rights activists. They were on the streets, and finally it culminated to the very important Civil Rights Act of 1964. Now, this is where, see the period, I'm talking about the period, that's why I'm taking you all to that history. 1960s is a period where America was on the streets. none other than for nothing else but for their right to equality. Now I'm taking to 1960s, the mid of 60s, and now coming to 70s. Now 17 is a time where America saw the worst of its time because the feminist movement started. Yes, when the feminist protests were on its top notch in American streets, especially at the point of time where you had, the celebrated feminist like Simone de Beauvoir, who with her remarkable work and literature of the Second Sex book and all, that was America was celebrating on the streets through protest. I would use the word celebrating. Why? Because it was indeed a success that America saw. I mean, at least for the feminist activists. Okay, so the period is 1970s. Now, I'm going a little like a storytelling because this is quite interesting because you need to place RGB in that point. Because as I told, RGB, the phenomenon is born at that point of time. Now, as I already told in an earlier session when I was introducing in one of the sessions in Littles, RGB was had did a law school in Harvard Law School. As a student, she joined there, and the interesting part was that amongst the 500 male students, there were only 6 female candidates who were enrolled in the Harvard Law School at that point of time. And as a student, so unfortunate that she was also, discriminated. She had to face a lot of sexist remarks saying that, hey, why did you girls take up the boys' seat? That was a question that she had to confront even from the so-called Harvard Law School professors. So she begins to hear this discrimination the moment she started her law school days. Now, the very brilliant women, a mother, and she was so fortunate that she was supported by her husband, another, the backbone of her, whatever she is. So she gets graduated from Harvard Law School as a topper. That's very important. And she was the first woman to be in the editorial board of the Harvard Law Review. That is even more important. Now, this bright, brilliant, aspirant begins to think, getting into the most leading MNCs of, legal firms of New York, because she was so confident, because she was a topper, that too from Harvard Law School. But things were not that easy for her because, again, America, as the glorified America that I'm going to tell you, was rejecting her every point of time just because of one reason. As she said, and I've read in one of the literature, not one reason, 2 reasons. One, she's a woman. Second, she's a mother. And third, she's adding on that she's a Jew. Okay, irrelevant for at that point of time. But then she said maybe all these combinations really didn't work for her starting up the career in law. But again, she took one thing determined in her mind, that when the street is busy with fighting discrimination, the activists were on the street. Justice Ruth decided to do one thing, that she is going to fight it out in the court as a lawyer. Now, when the streets were busy with the slogans, she was busy drafting one of the best of best pleadings through her position in American Union Civil Liberty, AUCL. She joined AUCL, and fortunate enough that she was having a good backup there, and she happened to pioneer works in the AUCL exclusive project for women. So there she starts a career of rejection, and then she is starting her so I would, when you read Ruth, Justice Ruth, I would divide her career into 2, as a lawyer, because there also she's made a lot of benchmark things, and as a judge. So as a lawyer, I'm going to start it with as a lawyer. So as I think all of you are on my same page with regarding to the time frame. That is the 1970s. Okay. So in 1971, Justice Ruth Berg is going to the court with her wonderful drafts, with one tool and with one weapon. And that was the weapon she had used throughout her life. That was the 14th Amendment of the United States Constitution. What does this 14th Amendment talk all about? I quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property with due process of law." And this is most important, and this is her favorite also, "nor deny to any person within its jurisdiction the equal protection of the laws. So with this particular weapon, she is starting her career in the law. Now, I have read through a literature that she said that the first job that she had to do was to convince the judges regarding gender discrimination. And you know what she did? It's quite interesting. You know, every time when she drafted sex discrimination, she used to say that, oh, come on, the sex word is like literally irritating. Let's make it gender discrimination, which is more, you know, attractive and makes more sense. See, that nuances, you know, just as Ruth took into consideration. And after that, most of her draftings, she used to mention gender discrimination because she had a huge task of convincing the judges of the then Supreme Court that what really gender discrimination is. And I'll tell you why am I emphasizing. See, 1970s is a time when the women, the US women came out of the streets, they came out of the households, started demanding rights to life, livelihood. Now, this was a very new social change for America at that point of time, because America has never witnessed such sort of protest, though they were. But this was a point of time when Americans were like witnessing a sort of a social change. And it was this point of time, Justice Ruth is coming to the court and asking for, no, you're not going to discriminate us on the basis of gender. So obviously she had to convince the judges who were very new to this particular situation that was going on, prevailing at that point of time in America. Now, so, and, interestingly, in one of her important article, with, Justice Ruth used to write vehemently, and in one of her article, which titles Sex, Equality and Constitution, which was published in the year 1978, she is mentioning that because, you know, there existed no historical basis for the premise that women are among the persons Congress meant to protect when they drafted the 14th Amendment, it was in many ways a weak and unproven weapon with which, to fight gender discrimination at that point of time. So, and it's very interesting that Ginsburg was telling that, 14th Amendment is an empty cupboard for women. It has, this Constitution, when it made the 14th Amendment, it didn't give any space for women. It was just an empty cupboard. That's how she's mentioning in her, this particular article. And that sounds quite interesting also. Now, so as she slowly convinced the judges, she started to, the best thing that she did was, she argued in the Supreme Court regarding the legal classifications based solely on gender, that till now, this gender was not in the suspect classification. See, I'll tell you what suspect classification is. See, suspect classification is that there is a chance of suspecting that this particular identity, or like, for instance, if you're taking America, at that point of time, if race is a particular issue, there is a chance that a particular person is suspected to be discriminated on the basis of race. Okay, so till now, gender was not at all into the suspect classification. So this is how the brilliance of Justice Ruth was here. She demanded that gender should be included in the suspect classification, and it has to be subjected with test scrutiny when challenged under equality clause. Okay, so this is how she started her, most of the arguments that she premised was on this base. Okay, now, interestingly, what I would say is, people might misunderstand that she only stood up for women and women's rights. But the interesting part is that, what we can think about is regarding her famous brief in Weinberg versus Wiesenfeld, which is one of the classic cases that still holds very much importance in the legal scholarship, because I can give you a brief facts of this case. Okay, see, this Wiesenfeld is a widower of a working mother who died during childbirth, and he applied for social security benefits to aid in the care of himself and his newborn. Okay, because he was newborn and he was not able to go out for job. But however, he was told that when he approached for the benefits, Wiesenfeld was told that he cannot avail the social security benefit because it was exclusively for mothers. Now, this is a huge dilemma at that point of time. So this particular matter came up to Justice Ruth and team, and they challenged this particular act. And the Brilliance did really work with Justice Ruth, and and on this particular act, the court denigrated, overturned the act, and it said that it agreed with Justice Ginsburg's assessment that such law denigrated the value of a female breadwinner support also, because he's a support. So this is how she's starting. So, this is where you have to see those people who think that Justice Ginsburg was a feminist or the so-called only a women's right activist, then it's wrong. And she never liked to be called as a feminist, because she says that you are again going against my very basic theme that I stand for both the gender. So it's not about just one. There are a lot of gender stereotyping that is happening against men too. For instance, in this case of Ginsburg, that he wanted to be a homemaker, he wanted to rear a child, but the so-called law was not permitting. Leave apart law, even that point of time, America was not grown up enough, I would say. I'm using the word grown up because they was not able to understand, oh my God, how can a man look after the household core? So probably the legislator who made this was never even thinking in that sense, in that direction. Now, so this is how I would like to present her as a lawyer, because I would say, if you're really interested to read around, regarding Justice Ginsburg as a lawyer, there is an interesting article, and one of the, the literature which I found very interesting was written by David Coley, and the title is very interesting: Strategies of Difference, Litigating for Women's Right in a Man's World. So this is his article's title, and this particular article, if I can even give you the citation of this article elaborates how Justice Ginsburg was, fighting it out in the all men's club at that point of time, because the Supreme Court was all men club at that point, until, as Advocate Prem said, Connor came into picture. So this is how she, as a lawyer, the world has seen her, and how the legend, passed it out. Now, a very important thing that needs to be told about, as I said, she was totally against biased laws. That means she always stood for gender neutral laws for women. The wonderful article that she have articulated in that, which she herself has written, which the article is titled Some Thoughts on the 1980s Debate, which was over special versus equal treatment. Okay, what Ginsburg stood for was, it is very dangerous to make laws and policies to include ostensibly womanly way of thinking or feminine reality. So she was totally against it. How can you even, why did she use this word? Because you do a lot of pigeonholing, you are again victimized. That was her concept. So she was and I want this audience also, probably after my deliberation on this, I want us to also discuss on this point. Are we reservation of boon or bane to women is still a question. And with her intensive research, she developed a theory called equality theory, wherein she was against the so-called special reservation given to women, because she said there was functionally no distinction between a man and a woman. Then why do you claim to have a special reservation? Now, this was her proposal, and interestingly, there were a lot of criticism against this equality theory, because saying that certain women are elite, privileged, who don't have any differences amongst us, but there are certain women, I guess, have I mean, um, internet is working. Am I audible?
Yeah, you are audible, no issues. And
Yeah, the current is going on and off,
even otherwise, there is sufficient fluorescence. Don't worry, go ahead.
Okay, so yeah, so what was it like? Yeah, so Ruth was totally against this concept of giving special reservation to women. She was saying, "Ki, you are sort of pigeonholing. Then what is the purpose of then we fighting out for equality? Men and you are same." So I think this is one of the most interesting moot question that I would put it across, and it had a lot of criticism against this particular concept, equality theory. And I really wish this particular audience to also deliberate on this. Now, coming into Justice Ruth now. Till now I was speaking about the attorney Ruth. Now it's Justice Ruth. Now, as Advocate Premraj said, there have been a lot of judgments he quoted, but I'm not referring to any of those because I've been very choosy when it comes to Justice Ruth, because I love more of a dissent judgments, as all of them call her, the great dissenter, rather than her concurring judgments. Now, RGB enters to the Court of Justice in the age of 60. Okay, but she's quite aged at that point of time, but then still, she was in the chair, I mean, as a judge till she was, till last 10 days. So that charisma she held for was always reflecting throughout, and age was not a bar. And interesting facts are also there. She was a hardcore workout. She used to do a lot of hardcore workout, and so many others. I would tell later on after this particular deliberation. So yeah, basically one thing that she always held for was that equal dignity of individual is a part of constitutional legacy. And she time and again said that, shaped and bequeathed to us by the framers in a most vital sense. So this particular line and quote always reflected throughout Justice Ginsburg's judgments, this particular line, that equal dignity of individual is a part of constitutional legacy. You need not go anywhere. It is within our constitution. Why do you want to even hunt for it? So this is what Justice Ginsburg stood for. And there starts her career as a judge. Now, the most celebrated judgment is none other than where she authored for 6 judges in the famous case of United States versus Virginia. The citation goes like this: 518 US 515, page number 515, 1996 judgment. Now, this particular case is, I think I had put across this case during my introduction last time in Letils, wherein it says that the United States challenged the Virginia Military Institute's admission of only men in this prestigious military college. They never gave a chance for women to get into this college. This was challenged, and fortunate that it came before the bench of Justice Ruth. Now, this particular judgment, this particular policy of this admission policy was challenged, and it was held by Justice Ginsburg that it was unconstitutional under the Equal Protection Clause. And I quote certain things, ratio that she put across to us, which I quote: the Equal Protection Clause guarantees full citizenship stature to women and men, a stature that assures equal opportunity to aspire, achieve, participate in, and contribute to society based on the individual talents and capacities. A prime part of the history of our Constitution, she said in the judgment, which I quote, is the story of the extension of constitutional rights and protection to people once ignored or excluded. Our comprehension of we the people, she's stressing the word we the people, is expanded, and institutions like VMI have to match that evolution. Okay, brilliant, articulation. So she goes on saying, we are a nation on the move, not just in our wagon trains and automobiles, but in a commitment to equality. So this wording was reflecting a passion towards a particular theme that I said, just before, that equality is a constitutional legacy. That's what, that was what was reflecting in VMI, this particular case, State versus Virginia. Now coming into the most important, another judgment. So now I'm taking you to, I'm taking into the demosprudence. Demosprudence, in the sense, it was coined by Bakshi sir, Professor Bakshi, wisdom of a judge. That is what demosprudence is. So I'm just taking the audience towards the demosprudence of Justice Ginsburg through a couple of judgments. I'm not taking much of it. The most important is, as I said, I'm only taking up the dissent judgment because I'm fond of her dissents. And one of the classic dissent that she made was in Miller versus Albright, where she strikes the same chord of equality, opportunity, and individual liberty. Now, in Miller, I'm just taking into a small, brief of it. A fractured court confronted the constitutionality of an Immigration and Nationality Act provision distinguishing between illegitimate children that was born outside America to citizen mothers and citizen fathers. Now, Justice Ginsburg, writing for herself and to other two judges, considered the provision a clear violation of equal protection. Quoting Bernita Shelton Matthews, the first female US district judge, Ginsburg concluded in Albright that whether there are a lot of people who suffer or whether there are few who are suffering, it's irrelevant. From gender stereotypes, it seems to us that the principle of equal protection of law to men and women ought to receive recognition. She was very adamant on that part. Irrelevant how many of them suffer or not. But any gender stereotyping, we do not leave any room for anybody to suffer. So this was one of a classic dissent that we all celebrate. And moving ahead, there is interesting part also. As I said earlier, Justice Ginsburg was, has troubled women also in a particular judgment through a dissent judgment. This fact is really interesting. I want the audience to hold on with this particular fact, wherein, in this case, Justice Ginsburg put across in wherein this I'm just giving you the facts of this case in Bequests versus Michigan. The citation goes as 516 US 442 1996 judgment, wherein Justice Ginsburg, here it is concurring judgment, okay, wherein in Bequests a bare majority of the court sustained a state order forfeiture of a couple jointly owned automobile after the husband was caught cavorting with a prostitute in a car's front seat. Okay. The academic commentators and media pundits chided Justice Ginsburg for voting to uphold the forfeiture of the wife's half interest. Here, Ginsburg, took up the wife's half interest in that particular automobile. Okay. Now, the question was, how could a feminist like Ginsburg make a woman pay for a husband's fault, husband's sin? That was the whole, that was what the entire issue was. Now, notably, all four female jurists who reviewed the Bequests case, came to the conclusion that Tina Bequests is an economic actor fully equal to a husband and other men. Okay, so all property owners who voluntarily entrust their property to others risk forfeiture if the others uses the property for illegal activities. So from a constitutional perspective, so, this is more interesting. Wives are no different from husband, brothers, fathers, or neighbors in this respect. So here, what this Ginsburg is telling us is that, come on, women, if you choose to fight for equality, you should also bear the liability. This is what Ginsburg stood for. And this is where the true meaning of equality is also coming. You are always asking for reservations, you are always asking for privileges, but you are not bearing or boring, any sort of liability, then that doesn't mean equality. Then that is what this particular judgment in Bequests versus Michigan came out. So I found this quite relevant also for the so-called radical feminists who fights saying that, we women are not supposed to bear any liability when it comes to feminism. So this is where that's what I wanted to bring out the other picture of the so-called equality meant by Justice Ruth. Now, more important, apart from gender, she was also very vocal about things around racism also, because as I told, America is still suffering of this racism, and very clear from the current events that is happening in and around America. The curse that America is having is racism, and this is where judges like Justice Ruth, in her celebrated judgment of Adran and Constructors versus Pena, I give you the citation 515 US 200 1995 judgment, wherein in her dissent judgment she says that, job applicants with identical resume, qualification, and interview styles still experience different receptions depending on their race. This is a trauma that she's stating in the dissent judgment. White and African American consumers still counter different deals. Now, people of color looking for housing still face, discriminatory treatments by landlords, real estate agents, and mortgage lenders. So minority entrepreneurs sometimes fail to gain contracts just because of their color. So this was her, a sort of, I would say, an emotional judgment that she rendered through Andrea Adaran. Was it reflects how she took care about her, brothers who were discriminated just because of the color. The same emotion was overflowing in our dissenting judgment in Gratz versus Bollinger, again, 2003 judgment. She stressed that unemployment, poverty, access to healthcare, everywhere disproportionately, they have been discriminated on the basis of race in America. This is a 2003 judgment. Imagine you are glorifying America for equality, then you're wrong. Because America have time and again proved that it has failed when it comes to the protection of color. And racism is still in their blood. And that's what we see today, the superior white majority that is, on the streets. And, this is where, these judgments are playing an important role. And she states in this particular Gratz versus Bollinger, she says like, the adult African American and Hispanics generally earn less than the whites, with compared to the equivalent levels of even with having equivalent level of education, this African and the Hispanics, they still are paid less. I mean, the case is in 2003. That's revolving, and that's very relevant. That period is very relevant. So, and now this is about race. Now coming into disabled persons, she had taken much care to craft her judgment. Again, in the case of Ormsfield versus Zimring, I would give you the citation 527 US 581 1999 judgment, where she said that unjustified institutional isolation, this was the word she used, unjustified institutional isolation of persons with disabilities is a form of discrimination. Now, violating Americans with Disabilities Act. Now, here she has elaborated a twofold concept of discrimination, noting that, which institutionalization, as she said, both perpetuates unwarranted assumptions that persons so isolated are incapable or unworthy of participating in the community. And at the same time, she severely attacked on the diminishing everyday life activities of these individuals just because you're discriminating them. Their family relationships, social contacts, work option, economic independence, educational advancement, and cultural enrichment, everything you're putting a halt just because you're discriminating the disabled. So here in this particular judgment of Ormsfield also, she showcased that equality extends to disabled also. Now coming into the most important, we are now moving a little out of the so-called binary of gender in the same-sex marriage, transgender. She is so vocal about supporting the LGBT community, and I think she had faced a lot of criticism also. Being a judge, how could you openly do this, support such a community? I mean, the so-called what to say, majority normatives. So she was able to break that in a landmark judgment of Fell versus Hodges, that judgment that came in 2015, where through her judgment, it granted same-sex marriage right to almost 50 states, and a hardened crusader for this community. Now, similarly, I mean, lot many articles have come around this particular judgment, because saying that how could she go against a Catholic thought? America is still struggling with that. Now, again, I had mentioned, as Advocate Prem also mentioned, about the judgment of Ledbetter versus Goodyear Tire versus Company in 2007, where she again fought for gender discriminatory perspective, when it comes to work. Now, I'm sort of, winding up here in with regard to the judgments that she's delivered. Now, the question that I'm putting across to the audience is that why are we discussing this today is more important, and what is the relevance of Justice Ruth to us? Well, the whole globe is in a particular scenario where the majoritarian thoughts, the so-called white is supreme, a particular religion is supreme. I mean, a particular so-called heterosexuality, my sexual orientation should be this way. So we are countering each and every time. For instance, why I wanted Justice Ruth to be read, because I really wished if Justice Ruth was reborn in India, what all changes India could have got if she came back to India. She was reborn in India. First thing, I'm very sure she would never be a judge, for sure, because of reasons best known to all, for whatever things that she's held for. See, why am I stressing this? Because America has been able to nominate a judge like her who had no political affiliation, who was neither a conservative, neither a Democrat, but still America chose to support and elect her to that particular post of judge. Why? Because she stood for a cause. And this is where America stands different from India. Why? Because meritocracy holds a lot of importance in America. They looked across, the efficiency, the spirit that she held throughout her career as a lawyer, and that is one of the reasons why she was and what she has delivered to us. Now, as I said, I put it to the audience. Now I want a deliberation on certain things. Like, what if Justice Ruth was back in India, reborn in India? What would have been the fate of certain judgments? And I put it to, especially Justice Ramkumar sir and all those, Advocate Prem and everybody. Like, for instance, I would say regarding the Sabrimala issue, I was wondering if Justice Ruth was there, we would have never got a review done again. Wouldn't you think that? I'm putting across this debate to all of you. And similarly, the recent case of, the same-sex marriage that we're going to debate, and the government of India has told the court that it's against our culture. So this is where we want a Ruth. This is where we want a Ruth, because your culture and my culture is different. But I just look across the constitutional legacy, and I just want one thing to happen, that is equality, nothing more than that. So that's what I wonder, when I read more about Ruth. I really wish I wanted a Ruth around us who will not say that, oh my God, you're a transgender, I'm not going to take you up with me, or you have different sexual orientation, you are against me, or you belong to a minority, we can't take you up with us. So so this is how I'm going to conclude. I'm putting across a lot of thoughts to all of you, saying, why don't we have a Ruth born in India? And is it possible to have a Ruth born in India? Maybe, I hope so, we can. So I'm ending my session here. I think I didn't make you all bored. Let's see now how we deliberate. Thank you so much for being, with your patience, you've listened to me. Thank you so much.
Thank you, Neema, for that presentation. You could have at least paused to take breath sometimes. We were having a feeling that you're going to be breathless. Ramkumar sir.
Neema, excellent articulation, Neema.
Thank you, sir.
It was, in fact, the topic introducer virtually metamorphosed into the speaker himself. Of course, with your consent. It was interesting to hear that Justice Ruth was ruthlessly fighting against injustice in any form. She was a real. In fact, it was such a wonderful judgment. If such wonderful judgments came from a lady judge like Justice Ginsburg of America, what is the justification in American Supreme Court having only 4 lady judges to quote Premraj? Only 4 lady judges. They have been the bedrock of gender equality, of ostensibly, at least.
Yeah, it's a myth actually. It's a myth actually. That's what you're trying to highlight. America was deceiving us.
Yes. The position of the Indian Supreme Court is also no better.
Yeah, correct.
But we have more judges, than America, at least in numbers.
Where is the equality?
Equality, exactly.
Where is the equality? Article 14 will strike at the root in the appointment of judges. Then on the Constitution of America and India, comparing, I would place the Indian Constitution on a higher pedestal than the American Constitution, since we don't have amendments to the Constitution numbering nearly 4 times the total number of articles in the Constitution. That way I will place the Indian Constitution on a higher pedestal. Of course, it is all because of our articles are...
Ramkumar sir, it seems that
Somebody ruthlessly cut you out.
Ramkumar sir, we cannot hear you. You are not audible. You are not visible.
I think that is some.
Audio is not clear, in fact. The audio is not clear.
Higher judiciary.
Sir, we didn't hear you, sir, for the last 1 minute because there was some problem with the connectivity.
I see. In my case.
Yes, sir. Yes, sir.
See,
A lot of disturbance in the audio.
You wanted Ruth to take a rebirth in India.
Yes.
Why not the soul of Ruth enter Neema? And why not Neema become a judge of the Indian court, higher judiciary, and continue what she left from the stage at which Ruth left us.
My God.
Great
Notions.
That I can get, sir.
It is possible, is it not? Such migration.
So collegium system.
Metamorphosis, sir.
Yes.
Collegium.
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 Less said the better. Less said the better. Anyway, I don't want to publicly denounce. Less said the better about collegium. Yes. Yes.
Thank you, Ramkumar sir. May I request Pradap Kumar sir to say a few words?
Was that me?
Definitely. Go ahead, sir.
Yeah, okay. I mean, when you talk about Ruth Bader Ginsburg, it's something, she was actually prompted into all this because of maybe 2 incidents that she had gone through. The one was when she was seeking an appointment, to be appointed as, as a clerk on a clerkship position. And I think she was rejected because of her gender. And then I think she actually got into clerkship again. And then she stuck there for another 2 years. But all these inspiration to her that came in was when she had to co-author a book, in Sweden, that is, on civil procedure in Sweden. That was actually what inspired her into, the gender equality part. So in Sweden, I think that is one country where you have around 20-25% of law students of there were women at that time when she joined up. So I think that too was an inspiration in her, the gender equality thing. And the funniest part was she fought litigations that she took up was for men. What she actually wanted was equal, that is equal in, not when it comes to gender. It is the same. Whether you're a woman or a man, you need to have the same equal rights. You cannot discriminate a man having certain rights, and then you have a different law that says women as such, so they have a separate law. Like we have here, women can be raped and men cannot be raped and things like that. So everybody can be raped. See, the gender equality thing. All these things come in here. There's so many questions that are, it's there for you to take up. But nobody has the guts to take it up. I don't know why, because maybe the lordships there don't cotton to certain things. From what I think we all know in our fraternity, that the judges are, there are what do you call, very selected few can come up there. You need to have a godfather, you need to have somebody, and maybe new can come up, but as long as you have a godfather, okay, fine, good. So where is the equality? We all talk about equality, but do we practice? Okay, anyway, Ruth Bader Ginsburg did it. That's because that's America, the land of liberty. They talk about liberty, but do they have their liberties? We do have the natives, hanging out in the reservations. They have no right in their own land.
Correct.
And you call that the land of liberty?
Exactly.
Okay, anybody coming in from outside has a liberty to do anything they want? Is that what it is? Is that what you call liberty? You bring in a statue from France and stick it up in New York and say, this is a statue of liberty.
True.
Well, that's fine.
Statues are scary.
Do the Americans have anything that they call their own?
Yeah.
We have. What we need to do is we need to work on what we have and which we don't intend to. I think like Prem said, we have the most voluminous constitution in the world, and America has the shortest. It doesn't make any difference. What's the point in having a voluminous constitutional book, which just remains as a book? And nobody intends to follow it to the book, that is. Now, I know we do have a lot of, stalwarts in this group right now, so I shouldn't be talking about them. So I think I should give them a chance to talk on this and, sort of enlighten me on these, the imbalances that is there. Because a lady holds the balance, but I don't know where the balance goes, but it needs to go somewhere. Only thing is that you need to take the blindfolds off. And she's blindfolded, I tell you.
Lighter vein, it is said that the Americans mourned on two things. Number one, when the bottle of Coca-Cola, the shape changed. And number two, when Superman died of kryptonite. So the history starts and ends with some sort of
the
comic
audio
strip.
is not clear, sir. The audio is not clear. The audio, it's not clear.
Okay, I was just mentioning
I know something wrong with the audio.
Can you hear me now? Am I audible?
Hello?
Yes.
Okay, I was just trying to draw a parallel in the sense like when we have cultural and other heritage and when we talk about history, Americans' history, apart from the slavery and things like that, is limited to the grievance of change in the shape of the Coca-Cola bottle, because they think that there is some sort of historical cultural heritage in Coca-Cola bottle and the death of Superman.
There's a better way of putting it, I guess.
Thank you very much.
A very young nation to talk about anything.
Absolutely. The very fact that
Except
they can
the
have...
exploitations that they have done.
No, I'll just stop it because... KVJ Rao, sir, you got something to add?
Not much to add, yes, like there is a gender inequality in our country, there is no doubt about it. But sometimes when I look at it, like I told you, since 1998, I was a general secretary of the Air India Air Hostesses Association, a man standing out for a woman. But then you find at the end of the day, it is sometimes the woman itself who's the enemy of a woman. A man would like to support the woman, but it is the women themselves who stand against themselves. And I will give you a classic example. Like I said, there are two Supreme Court judgments wherein the Supreme Court turned down the right of an air hostess to become a flight purser or an in-flight supervisor. There are two judgments. We fought that tooth and nail. If you remember, I mentioned it during the Dushyant Dave sir when he came here. He was my opponent at that point of time. We won it. We won it in the Supreme Court. They turned it down. We got a presidential order. Can you believe it? At the end of the day, the women said, okay, now we can't fight anymore, so we will share it equally with men. We don't want a seniority based on the date of joining. After having fought for practically 10 years, and I was maligned in my own community being a man standing up for the women's rights. So having seen it at close quarters, at the end of the day, it is a mindset that needs to change, and it needs to change on both sides. I'm not saying the men needn't change. The men need to change. The women also need to change. And that comes from home. That will come from the upbringing. It is ultimately what you teach at home is what is going to go out into the streets. Like even today, when my son goes out with a girl, I say it is your duty to drop her to the doorstep and then you come home. You will not leave her at the end of the road. So end of the day, it is like I said, it is for us to I don't know what to put, because like I said, I've seen so much of it, Shyam sir, that like, it really, sometimes I'm wondering what is going right in the society today.
I know. I mean, we never had any qualms when we had a woman as our prime minister. We never had any qualms like that.
But
no, but
Nair sir,
I think it's all the wrong notion of these, the so-called activists who have this, that word in itself has been, raped, right and left.
But Nair sir,
they don't even understand what the word activist is like. So I think they should, the activists in India should, especially the women activists. I mean, I don't think we have any men activists except for in the ML, which is the Naxalbari or whatever that you call it. So, but when it comes to women activists, I think they should learn, take a lesson or two from not Justice Ginsburg. That's something that they should, because she fought for men's equality as well. It's like she never separated men from women. What she wanted was equal gender, that justice should be equal for everyone. And it should not be segregated on a line where you call you're a woman, you're a man, you have a separate rule, you have a separate rule, you have certain hierarchy on certain things. No, that's not how you go about it. If a woman is good at doing her job, why not she take the top post? You could. Let her do it.
Nair sir, a small correction. The Prime Minister that you speak of actually ruled with her iron fist.
Yeah, but then her fist turned out to be bondage because, she had, there is a bad side to having an iron fist kind of a thing. You know what happens? People who are there along with you seem to drop out in the long run.
Yeah, true. I agree with you.
Yeah, that's what happened to her, because what power got into her head. That's why she had all that playing with the...
Sir, the point appears to be that Sri Lanka and India could have a women prime minister, but America till now does not have a woman president.
Yeah, that's equality. That's inequality. I know they would never opt for it. I guess they don't want to array behind a woman.
See, Shyam sir, basically America is the West and the Western rules. The macho, the cowboy image,
right?
The cowboy image, women subjugated.
We don't have cowgirls. So.
Yeah, very few. How many cowgirls do we have, Shyam sir? Or how many have you seen when you go to
I don't want to use that term again. Let's say I'll be hauled up for something else. Vijay Rao sir, what you said is absolutely correct. I mean, the change of perception should start from home. Instead of saying that boys do not cry, it should be taught that they don't make others cry. So, I mean, that of course is a nice point. Well taken also. And I think Nitin has got a question. Nitin, what is that? Please.
Thank you, sir. Not a question, but sir, only kind of a thing I wanted to share. So generally it was shown to us that, even I do not know, I used to hear Sadhguru also onto the YouTube channel. So he used to tell us that in our country, the women's were worshipped and they were really ahead of men. Even though, let us be very honest, the married men, at the home only the women's Raj is only going on. It is not the men Raj is going on. We have to be very honest. Even at my home also, my mother says and we have to follow it, or later my sisters also. So I am of the opinion that even the right history has not been shown. It is always shown to us that somewhere we are down and the US and all that, they are upper than us. And I think our history has been written. And one thing for a Prem sir, he is having brilliant memory. I am very fond of him. So many things how he can recollect. It's unimaginable. I never have seen such
Nitin, Nitin, something wrong with your audio. And Nitin, once you come out of the cocoon of this protective shield of mother and sisters, you will understand the real big bad world and what all things. Forget about the different genders. Everybody has to face. You might there will be a change of perception in the long run. Let's see.
Yeah, I agree.
And I think I won't go back to Prem again because, of course, Prem, if you got something, because I thought today we'll have Jaymon conclude the session. Because before that, Prem, of course, Prem, we would like to hear from you because you introduced and left from there. And thereafter, we had the presentation. First over to you and then over to Jaymon.
Okay, then as Neema, towards the concluding part, she was soliciting the partakers' view regarding that we are also waiting for an Indian Ginsburg. Now, first of all, let me just tell you, Justice Ginsburg, she joins the pantheon of legendary justices, and that too in a tech-savvy world, which made her a very popular icon that perhaps lack of technology would have denied this particular thing others before her. The question which Neema posed, why can't India have a Ginsburg or RBG? See, now we have women in the Supreme Court, with 2 women judges right now. When after Justice Bhanumati just retired a couple of months back in the Supreme Court, we have High Court judges also. But see, it is a male-dominated field. Even in India, where we say that we practice equality of law, when we have Article 14, we also have a very, very long road to cover. See, unless our judicial appointment system itself, which now remains very opaque, shielding and nurturing what I would say it's a transactional approach which is shared by the executive and the court, until our lawyers and judges, they rise and prosper on account of the merit alone and not on account of accident of birth in some judge's plan or the lawyer's plan or their political or societal connections and gender. And until we have a system which produces judges wedded to their oath to protect and defend the very constitution which we call the holy book, and not to solely secure their progeny and retirement, we can be confident that no RBG will come our way. And there is no reason to imagine that a single judge cannot sustain the fame like Justice Ginsburg, what she did or what she was a flash in the pan. And kindly see, Justice Ginsburg, she fiercely advocated feminism. Of course, both genders, I would say, not only feminists, not only in her judicial opinion, but also of the court. And she has shown to be, I would say mostly it is the female identity which she has shown. Now, even in India, we don't need a female. Even a male Indian Ginsburg would do. Need not necessarily be a female. We have seen our own apex court smashing against a Dalit judge in a case of contempt, whereas in another case of contempt, because of progeny, whatever, I won't comment, we have seen a 1 rupee punishment being given. See, this is where we stand after more than 7 decades of our independence. And kindly see, we have one judge, Justice Indu Malhotra, who was the first female judge to be directly appointed to the Supreme Court. And she is the only one who has been handpicked from the bar. Now, if you compare this with US, would you say that we are ahead of US, even though US is having only 4? And mind you, those 4 are in the highest court, directly picked. And mind you, India has seen more than say 250 and odd judges within this particular span. Whereas US, which is almost like 3 times our constitution, because it was in 1788. See, hardly 150 in total, maybe 150 in total, not even 150. So just see, where do we stand and where do they stand? We cannot.
Prem,
Yes, sir.
even in America, Justice Ginsburg could become a judge only at the age of 60, is it not?
So the thing is that, see, Justice Indu Malhotra, she became a judge at the age of 60. She is bound to retire to 2 years, I think 2022. See, in our system also, see, that is towards the highest court in America. Now we have the highest court where we have just one judge who has been handpicked. And mind you, their system, it is direct elevation to the Supreme Court. Ours, we have the direct elevation method as well as by promotion. Seniority can be overlooked. How many judges they do in the Supreme Court within these 70 years? Directly handpicked, just one. And that too after 7 decades. And of course, in America, it was the first judge. She was appointed in 1981. True. But still, their high courts do have female judges. Lots of female judges. And where were we until now? And they never go by in which family you were born. Where do you have your connections? What is your political allegiance? Nothing like that. Even the public, you can see that the Senate votes. That means it's the public which is voting. And ultimately, judiciary, it's for the public. It's for each and every citizen. And kindly see, sir, let me just tell you one thing. Now, in the Supreme Court, in many of the high courts in the Supreme Court, and which we see in the COVID days, we have been seeing this through even in the office. Somebody cannot enter the court premises without a government-issued ID card. I mean the locals, I mean the public, not the lawyers. India, even though we say that we are a developing nation, around 60% or 65%, they are so poor that they cannot, this 60%, they cannot even afford to have a government issued ID card. Less likely to have an ID card. And we say that access to justice is a fundamental right, which is a guaranteed fundamental right under Article 21. So, aren't these 60% or 65% denied that fundamental right, and that too by the highest echelons of justice, even in the temple of justice, where they are denied public access merely because they don't have an ID card? Is it right? Is it? See, we have to change. Our mindset has to change. Each and every citizen has to bear this in mind. And we have seen in America, mind you, because the 4th Chief Justice of America, there was a famous decision, Marbury versus Madison. It's a very famous decision. You can see the particular Chief Justice, he himself was the person who appointed Marbury. He never recused when the matter came before him. He took up the matter. He considered the matter. That was a writ for mandamus. And he asked himself, then what else is mandamus for? But ultimately it was refused solely on the ground that their Judiciary Act of 1787, which itself was a midnight statute, that did not permit the Supreme Court to pass a writ of mandamus in such a manner. But for that, we would have granted. See, our judges, actually, do we have the fundamental right to speak? Because even when we speak, if something slips out of the tongue of a person who has less connection, we will be mulcted with contempt. We cannot speak. We cannot go against judgments. See, I never intend to go against any of the judges, but at least we should have the freedom to criticize the judgment, at least in a decent manner. But is our country permitting that somebody can criticize? If you have good connections, you can. If you don't, you are punished automatically. This is what we see.
You will end up in the prison without a trial.
Exactly, exactly. But sir, here in India, people, they have to change because the people don't have the civic sense. Even though we all enjoy freedom, we don't realize what exactly is freedom. We never realized what exactly is freedom. This is what we do according to our wish. That is not freedom. As Nitin has told, he listens to Sadhguru. What we do and to live peacefully and joyfully. Whatever we do, we should live peacefully and joyfully, and the others also. They should also be joyful. That is what life is. That is the fundamental of Article 21. We have expounded Article 21 like anything, giving it the highest of whether, going it in the widest amplitude. And can any judge tell me what exactly is Article 21? Because we have thrown the doors open in such a way that you cannot fix what exactly is Article 21. Anything falls under Article 21 now. This was not what the constitution makers or the founding fathers of the constitution ever intended. It is not to throw open Article 21 like anything. It is not like that. It has to be expounded in such a manner that every person abides by the law. Abides by the law, because we have been seeing politicians, they create havoc in the society. Ultimately, they get elected. They themselves, they would, of course, throw the cases overboard, which are pending against them. The courts, they are very lenient. See, if some of the politicians who are facing the trial, the courts won't even dare to. We have seen right from Indira Gandhi's case. We have seen Indira Gandhi's son Sanjay Gandhi. He went to a court hall and he demolished the court hall. Where was the Indian judiciary? Indian judiciary just took like Themis, the goddess of law, completely blindfolded. They never saw anything. If a normal person or if an Naxalite, he went to the court and did like that, he would be hanged. Maybe even though hanging only is permitted, he would be guillotined. But what happened to Sanjay Gandhi? Absolutely nothing. He went there, he demolished the court, saying that there is no court in India which can try my mother. What happened to the Indian judiciary? And we have seen many judges serving as stooges of politicians. Not only during those era, even now, but we cannot say in this platform, but because of the content. Now, kindly see, whenever a poor litigant comes to the court, does he get justice? Even if he gets justice, it is absolutely so delayed that he can never enjoy the fruits of that litigation. If at all it goes his way. We are too late to deliver justice. We have seen scores of civil cases, where big civil cases, where there are many parties, say like hundreds or 200s or 300s. Some person may die, we have to implead, it may abate. Again, you have moving petitions after petitions, controlling the abatement, impleading the legal heirs, and the cases are going on 1 decade, 2 decades, 3 decades, 5 decades, goes to the Supreme Court, gets it remanded back, starting a fresh bout. Where do we stand? Where is the finality attached? And as lawyers, we owe certain obligations to the society. Are we really doing that? I don't think that all the lawyers are doing that. Few lawyers. And kindly see, if a particular litigant goes to the Supreme Court, suppose his adversary is a big man and he drags him to the Supreme Court by way of an appeal, and he engages some big lawyer in the Supreme Court, can an ordinary layman afford at least a class D, because we have categorization among the seniors in Supreme Court, class A, B, C, D, based on their fee, even a class D or a class E senior advocate? It is beyond this imagination. And we still say Article 21, this is India, where we have the freedom, everything. Is it Article 21? Does he enjoy the right to life? The right to life also includes the right to appoint a lawyer of his wish. And of course, I won't say that the lawyer shouldn't charge exorbitant fee. But they have to understand one thing. A poor litigant also is entitled for legal advice by big lawyers, despite he coming with an empty wallet. And we are still boasting that India is one of the greatest democracies. I don't think so. We have to change.
Prem, it is multifactorial, Prem. I mean, it is just like saying about the elephant tusk or things. When the buying stops, the killing also stops. We sustain the system. We promote the system. You want senior lawyers. You want somebody who takes so much of money so that if the person engages him, get his 1/3 or 1/4. It's a chain.
Okay, let me ask you one thing. What is the statute which governs advocates? What is the name of the statute? The name of the statute is the Advocates Act. The statute recognizes only one class of advocates. And so, then you have a specific section called section 16, which says that senior designation is possible. By which process? By the process which is mentioned therein, and subsequently which was clarified by the Honorable Supreme Court in the Indira Jaising
case. Yeah.
Kindly see. After being a senior designate, normally there are certain procedures to be followed. How many senior designees, at least in Kerala, of course in the Supreme Court, many of the seniors, they follow them.
Disabilities,
behavioral protocol.
Because even now it is according to the judge's wish. See, it's based on a point system. 10 to 20 years, 10 points. Above 20 years, 20 points. In journals, 15 marks. So 35 marks out of 100. The other 65 rest with the judges. And if they go for a vote, 2/3 majority of present and voting. I don't know if it is present and voting or the 2/3 majority, because that has not been even finalized by any judgments. It is still open to a debate. Kindly see, there are lawyers who are not having enough volume of work, but they can even do better than the senior designates. They can speak better, they can do better, they know law better. And how many of the senior designates in Kerala do you find efficient? I had the occasion to see many. I haven't felt impressed by anybody, except of course T.P. Kalunambiar. He was very good. Justice Giri was good, but he was not designated at that point of time. Because it is not merely the process of, see, even in section 16 you can say, in all branches of law, it is not in one branch. And we have senior designates who are merely doing MACT work. And senior designates, you can have a senior tag only if you are in the High Court or in the Supreme Court. I can cite ever so many lawyers who are much more brilliant than many designated, because of course, just Senior Advocate K. Ram Kumar, he is an exception. He knows almost all branches of law. All branches of law.
Forgive my intrusion, Premraj. You know what? Most of the seniors is like saying, like, everything depends on folklore.
See, it's after all, it's a question, because we are on the Constitution, we are on equality. Kindly see, aren't there very great lawyers in the Mofussil courts? Of course, Shyamata, you may be knowing our senior Advocate T.P. Aravindakshan. We had P.U. Shivashankar Nair. We had Advocate Muthuswamy, Advocate Narayan Nambudiri from Palghar. You have scores in the law. Advocate B.G. Bhaskar.
Yeah, we do have grace.
Any lawyer who can compare with Advocate B.G. Bhaskar of Calicut. No lawyer can. Such lawyer of such immense potential. Why? Because he happens to practice in a Mofussil court. The way we are looking even at the profession, because ours is the noblest profession and we are the persons who are carrying the law forward and at least aiding the judges to interpret the law. When we ourselves are like this, can we serve the society? An emphatic no is the answer. You don't even need to think of that. That we all have to change. The mindset.
That was a very, very ruthless take on the system. So this is now.
Prem said it is happening in every field today. What you're saying today, Prem sir, like I appear party in person even in the High Court. I mean, the High Court has been kind enough to allow me to appear party in person. I have seen so much of travesty of justice. Can you believe it? I have 3 orders to file an FIR against the Cabinet Secretary of India, the topmost bureaucrat in India. I'm not able to do it. Why? Because the government is spending money. They get date after date. In fact, I was ticked off by one of the benches for saying, sir, they're only bench hopping. Otherwise, I'm having a problem. Other benches are refusing relief, but it comes to that particular bench, they get relief. What do I say?
Forum shopping. Yes.
You know, I have a additional chief metropolitan magistrate who has forged a prayer in his order. A prayer that doesn't exist has been forged. I'm seeking prosecution. I have not got a reply till today. 1 year. I mean, this is blatant. I mean, I understand the Judges Act protects the judge, but only when he acts judiciously.
Exactly.
In good faith. Only in good faith.
Sir, how can the magistrate, fabricate a prayer that I didn't make in my application and get away scot-free? He gets elevated now to the Sessions Court.
Nullified action.
So what do I do? Everybody talks of the Veeraswamy's case, but who actually discusses it threadbare?
That is why, because we don't walk the talk.
Correct, sir. I agree with you. Sir, if I tell you my background, I was thrown into the lockup for 11 days only because I took on the powers that be in the Civil Aviation Ministry.
I think, Mr. Babu, you are the father of Shreya Singhal, right?
Yes.
Justice Shyampadmanassociates. He's the
I
father.
I mean, in one of the earlier sessions, we had heard that story. I mean, that grueling experience as well.
11 days I was thrown, and the magistrate refused. The first magistrate refused to grant me bail, saying that we have to search for bombs and guns in my house. 11 days I was in the lockup. They didn't take me anywhere to search for those bombs or those guns.
Sir, if you do really have some, please spare some to us. It's high time we also took on to the arms, it seems.
No, sir, I am resisting, sir. Shyam sir, if I tell you what all I've gone through in the last 8 years, you'll laugh. I feel like it's like, I get, you will not believe it. One ACCM called the DCP and said, what are you doing? These are cognizable offences. File the FIR. And the police says, yes, madam, we'll do today, we'll do tomorrow. What more can I say, Shyam sir? The system is so bad. And everybody wants a Shivaji to be born in the neighbor's house, not in their house.
Absolutely.
And that
of course is there, sir. To the quintessence of what you are saying, just see, we have Rosario Contino has posted in the chat. If a woman respect another woman, India would never have to, would never require Domestic Violence Act. It is all the, if all the stakeholders, I mean, wonderfully put, I mean, all the stakeholders evolve and adapt to the circumstances and be proactive and responsible. In platforms like this, we need not sit around, wail, complain. There will be action, there will be some sort of reaction that would end up in something positive. So on that note, let us hear Jaymon and Ruth. Jaymon, out to you.
There is not necessity of a concluding remarks. We are not concluding anything. Because I don't think anywhere else in our country, there was a remembrance of these great lady judges. At least I could not come across. I am getting many webinar notices, but never discussed. Even in Supreme Court, we have a very progressive lawyers group. Most of them are active practicing lawyers, lady lawyers, but they also not chosen to take up such a wonderful subject. Anyway, we had a long deliberation of the subject, and we raised many concerns about the lack of or less number of women judges in the country. So I am putting it in some other way. See, in the last around 20 years or 15 years, especially when the national law schools started all over the country, the girls are more coming into the legal education. When the senior members of this assembly, then they started practices, probably one lady lawyer, two lady lawyers in a bar. I know when my senior and Mr. Shyam's senior and Premraj father, everybody was practicing or started practicing during those days, 1950s in Calicut. There was only one woman lawyer in entire Malabar region, Leelavati. Leelavati. Now, see, when I started practice around 26 years back in Calicut, there were having only 2 or 3 independent women lawyers. There were many lawyers, the numbers increased, but there were only 2 or 3 maximum in 10. those who are having a separate office. I know lady lawyers who were doing juniorship for 25 years, 30 years in senior's office. So that was the situation, but now it is changed totally. So maybe that system prevailed in the entire society was a reason for women's not joining in the judiciary also. But till at the same time in Kerala, we have Anna Chandi, who is the first magistrate or first women judge. And we have Justice Fatima Bibi, who is coming from a minority community, becoming the first women, what do you call, Supreme Court
Judge. Yes.
Supreme Court judge. And she was a Munsim, then got promoted, and we have to see that very wonderful elevation. So wonderful traveling of a women those times. So, but the problem is number. It's true that the numbers are very extremely low in our country, but we have somehow, when you are seeing the new judge selection list, the direct selection, not this elevation sort of things. I'm telling those who are writing exams and getting passed. So there, you can see more number of women judges in district courts and municipal magistrate levels. But the problem comes when this elevation process of things, the collegium system everywhere. That is the major drawbacks. Now, one minister of Kerala, you may not be agreeing with him, but he rightly puts, in my department, if I want to appoint a peon, he has to pass an exam, at least. But who is that judge who criticized me? Who selected him? So they selected themselves. That was his representative. You may not be. That was an example. So when this selection comes, we are going back. So that is because of the that point has to be deliberated in detail. It's see. There are excellent almost all the judges, Rumapal, everywhere, everybody who adorned the Supreme Court were excellent judges. You may be having some exception. There was a judge. I don't have any hesitation to say there was a judge in Supreme Court who wrote in her personal profile and published in the website. When she narrated the liabilities, he put her 2 daughters as liability. So this we also witnessed. No, this is a fact. We all know who is she. So these sort of judges were also there, but most of them were excellent judges, judicial. So even the judge presently presiding over Supreme Court, the recently retired judge, we can say many number. But the system, the legal system was so. I heard many times, even senior lawyers, when the lady lawyers coming for to join their office, they will be little bit hesitant to take them. There was an exception. Mr. Shyam is having maximum number of juniors as girls. That's a wonderful office which I saw in Kerala. So except 1 or 2 persons, everybody is girls. So he is happily. They are all working well and doing it. So this attitude of persons in the legal profession, this attitude of persons in the collegium, judges, that has to be changed. And I will tell you the one way we are progressing in women empowerment, etc. But at the same time, we can see. I don't want to narrate all those incidents. We are pulling down the women's doubts some or other way. So see, I put it in the chat box when last time, when we were discussing about gender equality, several abuses were happening here. Before that, I put it when we are discussing a case of women commissioned officers. I am very much sure that though the central government was not given consent only because of a particular bench that order passed. Otherwise, it would have been some other bench that would not have come. I am pretty sure about it. I don't want to discuss about that most controversial Sabarimala here anymore, but I'm not because it's still pending. But still, we have hopes. At the same time, we have to fight for our sisters. That's the problem. Now, if feminism is supposed to be a very ugly word for most of the male persons. But feminists, so they were giving many definitions I could see recently. But females are not, females alone are not feminists. Those who are thinking about rights of women, those who want to treat women as equal, they are all feminists. So we all should be feminists. So all judges should be feminists. So the feminism has to be has to grow up to that level. Anyway, today we had an end. That's what in the beginning I point out. I don't think anywhere else it happened in the country. We discussed about a beautiful judge, wonderful judge, who fought for not for ladies, women right alone,
Equality.
for justice in total. And excellent articulation by the speaker. We don't have any and the supplemental preface, suffix, everything by Mr. S.K.P. I have only one reservation against him. He will arrange somebody to say he is cute. Otherwise, otherwise he is a ready reckoner. He helped me in many times when I want to refer on an immediate solution. So he was also fortunately I was counting that this is the only one occasion that he has not quoted any judgments in his concluding that remarks. Otherwise, if you are asking him, hello, Mr. Prem, he will come with a
1940 Privy Council, page 105. Hello.
So this is so that was excellent, and others who spoke over so they were all contributed.
I want to add, like the credit goes to Premraj sir only because he was so adamant that we can't even make it delayed. We want to do this,
No. So that's why I tell you, Neema, I want to congratulate you. You came with because see, there are certain subjects we cannot postpone to some other day. That will look very odd that time. So that is happening. We used to happen. That will happen to everybody. Suppose we are making a joke. Suppose this will happen. We are making a joke. That joke will be suit for some particular time. So if you are putting it in a different context, this will look out. So this is the right time. We have to do it.
Absolutely right, Jayman.
And so the fantastic presentation, Neema, and we need to we are expecting more from you.
The venue is more important.
Thank you, Neema. Thank you, Jayman. Thank you, everybody. And for that matter, conventions or procedures of. Sorry, please, Pradhan Kumar sir.
A slight intrusion.
Absolutely no issues.
Okay, and before you conclude, I mean, I would like to say that Judge Ginsburg had a very good friend in Judge Scalia, who was always her opponent. And then after the passing of Scalia, what she had given a talk on this, and then she said, she asked Scalia as to why so much differences between us, though we are so great friends. And you know what Scalia replied to that, to Judge Ginsburg? He only said, I do not attack people. I only attack ideas.
Exactly.
And
Absolutely.
it seems that some very good people have very wrong ideas. So very bad luck, it says. So, the judges, the advocates, whatever, the fraternity should have that, the kind of a link, whether you're on the opposite side, you're on this side, that side does not matter. What matters is the whole thing called justice.
Absolutely.
Individuals are measured.
Now, Shyam, this should pave the way for an introspection into some of our great lady judges like Fatima Bibi, Anna Chandi, Justice Janaki Amma, all those things. Somebody should take up the lead.
Absolutely, sir. I mean, let this be the harbinger of those things. Let us definitely do that, sir.
Wonderful.
Definitely. And as we come to the end of the 127th session, I'm glad that we could change or break the convention in the sense like we had decided after the 100th, we'll have it only on Friday, Saturday, and Sunday. We broke the convention we had yesterday and we did have today because like Jayman said, if you have to crack a joke at the right moment. Otherwise, it won't be some. It would be entirely something different. Likewise, if you have to address an issue, it is just like saying that the right thing, a right decision taken after a long time or the wrong time is no longer the right decision. Simple as that. So we took the right decision, we took the right topic, we had the right speaker, we had the right introducer, we had the right person to conclude, and we had the right audience to interact. What else can? Everything fell in place. That is why this program is so beautiful today, that we were paying homage. And my hope is that the homage that we can pay to this great RBG would be, let us aspire for a gender neutral laws in the country. Let us not say that somebody is to be protected. It's just like Salim Ali said, never ever think of protecting lions and tigers because they require protection. Then they become subordinate to you. The majesty of the lion is lost. The greatness of the tiger is lost because they are all being protected by you. You are the master. No, let there be enough lions and tigers so that you can also roam around and shoot them if you want to. That should be the perception. So yes, hope and aspire that let there be a paradigm shift in the thinking pattern. Like the different instances Prem cited, I would say that all the stakeholders involved should be proactive. Let us not point fingers. Let us not wait for that Messiah to come and salvage us. Let us look into the mirror and say, it is me, it is I who is going to change it. I hope, like Ramkumar said, let us have a change and let us have a different perception. Let us analyze these fantastic ladies, not because they were ladies or feminists or something, but they were representing an ideal. Like Pradhan Kumar said, sir said, it is not the person I was attacking or I was supporting, it is the ideals or the theories or the philosophy. Let us also do that. Let us see how these persons against all odds, male or female, the distinction let us forget, rose to such high levels and still retain their sanity and were able to do wonderful things. And without holding any grudge to the system, which tried to put them down. Never, ever. So, while we say goodbye for the day, may I also request you to be there in the 128th session. That will be scheduled on Friday. It is Places of Worship, Special Provisions Act 1991, a critic by Sri J. Sai Deepak. He is an advocate of Supreme Court. And all of us know him for his wonderful presentation in court during the Sabarimala hearings, and he's also viral in the social media platform. Let us have his perception. Let us also share our thoughts with him. Coming Friday, 3:30. Till then, do take care, and let us hope that let us from home evolve a general, gender neutral outlook.
Thank you.